Hey everyone, this is Constitutional Law 2, the Supreme Court, Civil Liberties and Civil Rights. This course is part of a two-part constitutional law sequence that Texas A&M University offers. This along with Con Law 1, which is also known as the counterpoint to this course. Instead of being POLS/CRIM/CRIJ 4332, it's 4331. In this course, we're going to look primarily at the Bill of Rights and at the 14th Amendment of the U.S. Constitution. So this means all of those things that we like to say, I have a right to this, we're going to be looking at cases evolving around that. So this course is a constitutional law course, so our focus, of course, is going to be on the Constitution and who decides the interpretation of the Constitution, the Supreme Court. So we'll be looking at constitutional law rulings. A little background to myself in this course. This, as it says here, I'm Professor Travis Braidwood. I'm an assistant professor of political science. I've been here for about 5 or 6 years. I've taught this course at Kingsville about, I think this might be my 4th time, and then before Kingsville, I was at Florida State University getting my PhD, and I taught it maybe like 3 or 4 times there as well. So I've taught this a number of times. This, however, is the first time I've ever taught it online. Initially, this course was not slated to be online. It had to be moved because we realized that another upper-level course taught by Dr. Carranza was also going to be taught at the exact same time as my course. So since I have a lot of familiarity with teaching other courses online, I've taught Intro-American and Texas Politics both online. And then because of COVID, I had to switch half of my Con Law course, immediately switched online, and then all of my other courses had to switch too. That I was the one that said, okay, fine, I'll volunteer to make this course for the first time being offered online. If you, or have never taken an online course, I'm going to try and make this as painless as possible. One of the downsides about this is that it's going to lose some of the fun activities that we normally do in this class, and I'll explain that when we get to the syllabus. So here is my name, my email. This is also in the syllabus, and my office. I will have office hours, as I'll explain in just a second. Let's look at the layout. Actually, let's skip these slides. This just talks about the layout of the course. We'll see that on the syllabus. Let's turn instead to that. Let's look at the syllabus. So the syllabus here is also available on Blackboard. So go to the Blackboard site. I have it pulled up right here. There's a tab called Syllabus. At the time I'm filming this, it's blank because I haven't uploaded it yet because I'm still kind of tinkering. So it'll be available obviously right there. So let's take a look at the layout of our syllabus and go through, just in this intro video, what the course is going to be about, what I'm expecting of you, what we're going to be covering, and where you can find things to help you, right? So basic info, right? Information about the course, triple cross listed, so we've got some poli-sci, some criminal justice and criminology majors, right? Office info, title, email, and then here's my office hours. These might change. Check on the syllabus before you quote me on this, but as of the time I'm filming this, it's going to be Tuesday, Thursday from 1:45 to 4:45. At the time of filming this, I have 2 in-person Intro-American classes, so I have to be on campus anyway, so I might as well offer office hours. So I would say take advantage of these, especially when we get into some of the scenarios, what we call moot courts, because you might want to sort of use me as a sounding board. The course description you can read on your own. It basically just says what I said in the beginning, and that is we're going to be looking at the Bill of Rights and then how those provisions of the Bill of Rights have been applied to the states via the 14th Amendment. So it's Bill of Rights, first 10 amendments, and the 14th is our primary focus. Academic catalog, you can read that on your own. Student learning objectives, these are simply required sort of by the state. What I'm looking for, critical thinking, project management, this is going to be with some of the work assignments I give you, and the integrity and values, meaning you're going to cite your sources, you're going to do, creative work that requires you to actually, follow through with sort of proving what you know. The required text. So there's only one textbook. It's actually more of a case book. Con law textbooks take on one of 2 forms. One of 2 forms is probably accurate. One is it's like a textbook, and then they'll put in on very rare occasions like 2 to 3 pages of excerpts from actual Supreme Court cases. So I'm sure you're familiar with these probably but for the cases, right? Imagine like a regular textbook, but they have these sort of pop-outs of actual Supreme Court rulings, and then most of it's spent just explaining it to you. I don't really like that approach. And the reason why is because it's a little too like pedantic, and you got like some faceless person saying, this is what you should think, this is what you should believe, or this is what, how I interpret it to mean, or how most people do. When the alternative is the one that I prefer, and that is it's a case book. And so you have chapters, and the chapters summarize sort of all the things you're going to be looking at in that chapter, and then they have the actual case text in the textbook. So we're not going to be reading full cases, right? Because some of these Supreme Court rulings are quite long. Instead, it's an abridgment. So they take it, boil it down to the key components. In some cases, the textbook didn't even have the cases because they're really new. We've got about 2 or 3 cases that have come down in 2020, so I had to edit them down. But it's the same basic principle, right? You edit down these cases so you can read firsthand what the members of the Supreme Court are saying rather than getting it from secondhand. Now, this is the 10th edition. They actually have an 11th edition. I don't think they're on 12 yet. I think they're on 11. The 11th edition, I think, actually has 3 authors. It's no longer Rossum Tarr. It's Rossum Tarr and, I think, Ramirez. In terms of the book, the reason why I'm using the older edition is because it's cheaper. You can get this used for about $30, maybe even less. I haven't looked all across the internet. But as I say here, feel free to look online. Right, you can shop around. I recommend using Google Shopping. You can help you out. The one thing to note, you got to get Volume 2. There's a Volume 1. Don't get Volume 1. Volume 1 has absolutely no overlap whatsoever because Volume 1 is Con Law 1, which deals with the Articles of the Constitution. This is Con Law 2. We're dealing with the Bill of Rights, right? They're totally divorced from each other. So yeah, you're definitely going to want to do that. Now, sometimes I get a student say, can I use the 9th edition? You probably could. It's not that big of a difference. The issue is that as you get into newer editions, they swap out certain cases. So they might take out one case and then replace it with another, or they might just add in new cases because law is an evolving process. The court is constantly ruling, right? So if you want to get the newer version, you're probably okay. Probably cost you more. If you want to get the 9th edition, I would say try and steer clear of it if you can. I think the library might have this in their reserve, on their shelves. If you want to use that and not buy the book at all, you can, but you'd have to constantly be going to the library. If you want to do that, that's fine. But I ask that you please not check it out because there's only one copy, and if you do that, nobody else can reference it, right? Yeah. Additional resources. The library has this book on reserve for you. It's not required. It's a book by Sullivan, and it's called Constitutional Law. This is their 18th edition. They're now on the 19th or 20th edition. This is what law schools use they study con law as well. And most law schools do it the way that we do at Kingsville, and that is you have 2 different con law courses. One of them focuses on the articles, one of them focuses on the amendments. This one is the book that they use for both. It's this giant leather bound, it's huge. It's like imagine like 2 phone books kind of crammed together. And I mean, if you drop this on your foot, you could like break your foot. You could kill a puppy with this if you were so inclined. It is enormous, right? Now, the reason why I mention this is it's useful for reference because we're going to be looking at cases in this class where you're going to have to sort of answer questions about the case, and you're going to want more information. And so this book can be useful because you can just turn to that section, and it gives you a bunch of case citations, places to look, stuff like that, right? So it's a good reference. I would not recommend buying it unless you want to get you just want to get an older edition, or maybe you're going to go to law school. If you wanted to get like an older edition, then they're actually really cheap. That might help you. It's your choice. Okay, so let's look at the assignments for the class, and then we'll look at the Blackboard as well. So we're going to have, what is this, five different assignments, right, throughout the course of the semester that make up the entirety of your grade. And if you can do sort of quick math, you can realize that if you add 25 plus 25 plus 25 plus 15 plus 10, that adds to 100. So there's 100 possible points. I do this because it's easier that way on Blackboard. You can always figure out what your grade is. You go to Blackboard, you look at how many points you've earned, how many points you have left. Yeah, that equals 100, right? I never get I have some professors when I was an undergrad or even a grad student, and they'd say, you can earn 1,500 points. And I was like, what? Just make it out of 100. It's unnecessarily complicated. You don't need that, right? So this is just easy math, right? Now, one thing you'll notice at the beginning of the grading rubric is this. We are an online class, so we don't have days to meet, right? I can't say, like, do the reading or this assignment before this date. We have weeks, right? So instead, we're going to use the normal sort of calendar approach, and that is a week is going to begin on a Sunday at 12:01 a.m. So if you look at a calendar, Sunday's on the far left, right? So at the beginning of that Sunday, stroke of midnight, right, that week has begun. Then the following Saturday, 7 days later at 11:59 p.m., the week ends. That is a standard week, right? That's the best way I could come up with defining due dates is to look at week systems. So in terms of this course, in terms of assignments, we're going to have exams. We have a midterm and a final, just 2 exams, each worth a quarter point of your grade, or 25% of your grade. We're going to have 2 moot court exercises. In one of those, you're going to be acting as a judge, and in another, you're going to be acting as a lawyer or as an attorney. And then finally, it's a participation grade. Normally, for in-class portions of this, I do a call-on, and I would, we're going to be reading a bunch of cases, and so I'd ask people various questions about the cases. So I'd say, like, tell me the facts of the case, tell me the ruling, stuff like that, and then you either give me a correct answer or you don't. Since we can't meet in person, it's going to be easier in this aspect, and that is, all you have to do is view it. You simply have to view the video lectures like this one, and you get credit. Now, let's pause there for a moment because that idea of viewership and reading, I want to turn back to my slide and show you some of the distinctions here between the types of law we're going to be looking at and how to approach reading some of these cases. So when we broke off from the British Crown and became our own nation, we were faced with sort of a dilemma, and that is, how should we approach our legal system? Should we continue what we did under Britain, or should we forge something new? Right. So under the British system, they don't have a written constitution. So instead what they do when they approach cases is they rely upon a system of what they call common law. Common law means that I will look at how past cases have been interpreted, and then I will apply those past cases as precedent to apply to future cases. And this also will apply to how we read laws, right? How should we read statutes? How should they, we approach these things? This, by the way, is going to be in the first week of the readings. It'll talk more about common law versus constitutional law. So we broke off from the English Crown. We said, that's great. Got it. We have this. We'll just adopt the same practice. But then we realized there's a problem. And that is, well, we want a constitution, right? Because we're not going to be a unitary system. There is no English Crown, right? Instead, we're going to have a bunch of these several states. And initially, we formed this document called the Articles of Confederation. And then the states are going to be independent, right? They'll be their own sovereign nations. And then we realized, oh, that was a bad idea. It doesn't really work. So we're going to form a federal government. We're going to create a new U.S. Constitution, which is what we have now. And we're going to unite these states under one federal head, and in that federal head we're going to say that the Constitution will be the supreme law of the land. Nothing may violate it. The states and the federal government both must obey, right? This is called the Supremacy Clause. So we're faced with a problem. Unlike common law, which simply says precedent, 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 what happens in the past carries to the future, now we have a requirement that the Constitution must be the end-all, be-all. So we have adopted elements of both. We have both the Constitution, which may not be violated, and we have common law precedent, interpretation of what the Constitution means then in the past will also means what it means in the future, right? It'll carry forward. This also means that how we interpret laws and statutes, right? That's how those will be carried to the future. That's the idea of both. We merge common law and constitutional law. In the beginning, we also said, well, okay, let's stick with how Britain has defined types of law, and that is the distinction between civil and criminal law. Initially, under the U.S. Constitution and under British law, there was actually three types. There was the distinction between criminal law, which was true in English and in our system, and then the English system had civil law and something they called courts of equity. Equity meaning fairness, right? So these would handle disputes over things like property, while civil law would deal with disputes over things like, contracts, more ephemeral things. We realized, though, that you don't really need that distinction, right? And in fact, if you look in the Constitution, there's several mentions of courts of equity. But over time, we simply said, you don't really need that, right? Courts of equity are really just civil disputes. If I have a dispute over, this contract versus a dispute over whose horse is this, there's still disputes over property, right? So we folded courts of equity into civil law. So in our legal system, we just have these two types, criminal law versus civil law. Civil law are disputes between two parties over matters usually dealing with things like property or personal disputes, things like divorce, contract, torts, or it could be, faulty products, things like that, versus criminal law, where the state always is a party, right? By definition, a state must always be a party in a criminal prosecution. The state is levying charges against a private individual or private corporation, right? The state could engage in civil disputes. For example, the government could sue somebody for damages. Think like pollution violators. You could sue them for both, right? Violating a criminal statute and also a civil penalty. The difference is that typically civil cases are only disputes between private individuals. Criminal cases, by definition, have to include disputes where the government is a party, right? You could never have a criminal case where there's two people suing each other because citizens, civilians, we cannot enforce criminal law. So within law then, in this country, there's a bunch of subtypes of law. This is just a fraction. This goes on and on and on, right? I don't even know why I bother listing it, because those of you that go into law school, you'll realize this, that there's all sorts of types of law, and then beneath each of those, there's other subtypes. So you could say, okay, I'm going to focus on civil law. And then, okay, what kind of civil law? Are you going to focus on contracts? Are you going to focus on mergers and acquisitions? Are you going to focus on family law, which is, divorce, child custody? You're going to focus on immigration law, right on and on. You can imagine the sort of plethora of these things. Okay, so now that we've got our idea, it's sort of the sort of broad overview, broad strokes of law, let's turn to that idea then of how we approach these cases. Because what I want you to do when you're reading is to always look for the same things. And by the way, if I haven't said so already, I'm going to put these slides on Blackboard for you, right? So you can reference these things. So they're the same things you should be looking for in every case. Whenever you read a case, it's the same elements. And in fact, the textbook mentions this as well. These are the same elements you're going to be looking for. The reason why is because if ever you are asked to write a legal brief, by the way, is just a summary of a case. If you're ever asked to brief a case, these are the elements you would include. These exact ones, right? You're condensing a case down to like a page or two, like a memo, right? So whenever I did this in class for participation, what I would do is I would call on students and ask them to answer questions. And they would be these. I'd say, okay, what were the facts of this case? I would, let's say the case was like a famous one, like Roe versus Wade, deals with abortion, right? It's okay, what are the facts of Roe versus Wade? Well, Jane Roe, which is a pseudonym, not a real name, she wants to seek legal abortion in the state of Texas. Texas has a law banning access to abortion except in the case of life of the mother. So she's denied. She sues, claiming that she has a right. Right. Okay, there you go. Those are the facts of Roe versus Wade. Then I'd say, okay, what is the legal question or legal questions in Roe versus Wade? The legal question there is whether or not the right to privacy, as established by an earlier case called Griswold versus Connecticut, if it also extends to an individual woman's right to access lawful abortion. That's our legal question. Does privacy extend to cover a woman's right to access abortion? Next, what was the majority opinion and what was the ruling? Right? So these go hand in hand because the majority opinion is going to be what the ruling is. So typically in class I'd keep it easy and say, what is the ruling? Right? Who won? Does Roe have access to abortion? The answer, yes. Right? The court said, I believe in a 7-2 decision, that the right to privacy extends to a right to a woman to have access to abortion. Simple yes or no question. Right? And then from there we'd say, okay, and then here's the most important bit. Why? So the reasoning. Now, you might be thinking, wait a minute, doesn't the outcome matter? Because now, look, women can access abortion. Yeah, but the question is, well, when? Is it unlimited access? Why does she have access? What happens if states try to put barriers in the way? How do they approach that? All these questions are left open. That's why the majority opinion is the most important bit, because it's the reasoning that will guide us in future cases and guide lower courts in future cases. That's what's really most important here. So you would say, well, why did they reach that? Right? So the majority opinion in that case was that women have an expectation of privacy. They have sovereignty over their own bodies. The state intervening violates that notion of privacy and dictates, the medical procedures that women can or cannot have, and that's something that should only be between a woman and her doctor. And then they lay out this trimester scheme saying when women can access abortions during the length of their pregnancy. And then from there, we got it, right? That's our majority opinion. That's the reasoning. Concurring opinions, if there are any, you'd summarize those. Dissenting opinions. For purposes of testing, I will only address these in the form of bonus questions, I think for pretty much every case. So these concurring opinions are, I agree with the ruling, I agree with why the person should win, but not with the how. Like, how did they get there? So in other words, I might be one of the 7 out of the 2 justices that said, yes, Roe should have access to abortion, but I don't agree with how the majority reached that conclusion. My reasoning is different, right? Dissenting opinions, obviously, don't agree with the outcome. In some cases, they actually might agree with the outcome, like which side should prevail, but they don't agree with the reasoning is the primary thing. They don't agree with it. Usually, it's the exact opposite. And then finally, why does it matter? Right? What's the significance? Are there any sort of inconsistencies? What does this mean for future cases? Especially when we're looking backwards in time, what does this mean? What's going to happen? Right? What should we do for the future? So when reading through these cases, for a lot of you, it can be a bit burdensome at first, right? It's going to be a bit overwhelming because you don't really know what to look for, and hopefully this will guide you. While you're reading, always have this, I would write it next, maybe a note card, or have a bookmark, right? And then have these things written on there every time, and keep it in your mind. This is what I'm looking for. I need to be able to answer every single thing about the case. One of the best things I would recommend is, especially for testing purposes, is it's not a bad idea to make cue cards. like little 3x5s, and then on one side of the cue card have the case name, and then on the other side have these things identified, right? It's a good idea. So let's say you're getting stumped and it's not sinking in. It's too complicated. You're kind of losing yourself. Are there any other resources besides the textbook? Absolutely. Right? The textbook itself, as I mentioned here, there are chapters. We're not going to be reading the book chapters. We're going to be just reading the cases. But if you're stuck, the book chapters can help you a lot. So just flip back to the chapter that the case is located in. That can help guide you. That should be probably your first place to look. Another good resource, oea.org. OEA.org is run out of some university, I don't remember, and what they did is they digitized all of the oral arguments from the Supreme Court going back to when they first started allowing recordings in the courtroom. That was in the 60s, I think it was like 1969 or so, all the way to present, and they post those online. They also have, in a modern approach, the court started reading some of their opinions, summaries of their opinions from the bench, starting in about, I think like the early aughts. If those exist, they have those as well. They also have really great summaries of cases, right? Let me just show you an example. So here's OEA.org, Roe versus Wade. Here's the oral arguments. Here's the oral re-argument. They actually have them back later to answer some issues that were left open. Appellant, appellee, where it was argued first, docket number, argued which court it was argued in, the case citation, the advocates, date argued, date re-argued, decided. Look at what they have for you. Facts, legal question, ruling, which you can sort by both ideology and seniority, the decision, 7-2 in favor of Jane Roe, the reasoning, right? And then also they have, they don't have the dissents listed here. Normally they include a little bit about the dissents. But anyway, there you go. This is super great too. This is good for a summary, right? If you just really want to boilerplate it. This is actually a good idea if you're getting into, maybe if you want to skim over these first and then read the case, not a bad idea. Here's one thing I do want to warn you about though. If you rely on OEA.org and you're hoping that that'll get you through to pass the class, it won't. I try to write questions in such a way that you either had to read the case or you had to watch the video lecture or both. Because I want to test your ability to actually understand the material, not to simply skim, right? So you definitely need to read the material or it's going to be almost impossible to pass the class. You got to read the cases. Justia.com. Justia is a website that has cataloged every Supreme Court case going back to, I think, the founding to present, and it has it in HTML format. And then I think for newer cases that are in PDFs, they have it in that format too. So here, for example, Roe versus Wade, case citation. They have the syllabus, which is also a good summary, by the way. The Supreme Court starting in, I can't remember what year they started doing it, but they started issuing syllabi, which are like cover pages, and it summarizes both the facts of the case, right? And they don't really have the question. It's kind of embedded in the facts. And then they have the rulings, and it's summarized very succinctly, right? And they tell you who ruled on what side. This is also a really good resource. The other thing that's really useful about this is, if I click on case, for any case, it has the full case text. This is the actual ruling from the Supreme Court word for word. One thing you'll notice is, I don't know if you can make this out on your video, but occasionally you'll have like these little breaks that have little links. Like this one says 117, then here's 118, 119. These are page numbers. These are page breaks, right? So if you're wondering why it's there, that's what it's referring to. It's referring to like where it exists in the catalog. So that's a really good resource too if you're looking for full case text. Wikipedia, it's okay. If I had to choose, I'd probably pick OEA over Wikipedia just because, one, sometimes the summaries are actually longer than the court case. They're like, these have a lot of history and backstory, so it might not be useful. Also, Wikipedia, sometimes information is kind of crap. If I had to choose, I would definitely say do OEA, do your textbook first, because the textbook is abridged, right? The textbook has boiled down 20 pages into like 3, so that's the main point, right? Start with that. If you're still not getting it, check out OEA. Wikipedia, not really that useful. And then finally, Rossum and Tarr also have a website, but they don't really do a good job keeping it up, so it's kind of crap. So yeah, there you go. Those are some. Oh, wrong thing. Those are some additional resources for you to look at. When you're working through this, when you're reading these cases. So with that in mind, let's work our way through the grading rubric and look at how you can earn 100. So let's start with the exams, the midterm and the final. So it says there's a midterm, there's a final. They're going to be multiple choice, short answer, identification, and short essay. By short essay, I'm talking usually no more than 5 sentences. The exams are all going to be online. They're going to open the week listed on the syllabus. So, for example, if we go down to Week 8, here's our midterm. Week 8 means that it will open on October 11th at midnight. It will be open for a full 7 days. It will close on October 17th at 11:59 p.m. You can take the exam anytime you want during that week. It is up to you, right? It's totally up to your choice. Closes the following Saturday. There are 2 exams, midterm and final. Here's the one thing to note. These exams are open book, open note. You can use anything you want, but nothing electronic. So you can have paper to your heart's content. You can have flashcards, you can have the textbook, totally fine. Totally up to you. The one thing you cannot do is nothing electronic. So no doc files, nothing like that. There's going to be anti-cheating, anti-plagiarism software in place, so don't do that. And it's going to be available on this sort of specialty survey software that I'll link you to. It is, as I said, timed. So the one thing I would recommend is, this is why note cards are a great idea, and that is, if you want to be able to study for these exams, but you need to be really familiar with these cases. Law in itself requires a fair degree of memorization. So this is why I think flashcards are a great idea. When I took these courses when I was an undergrad, I would bring the cards with me, and when I went for I would get on like a stationary bike, or I'd have them at the gym, and in between sets, I'd flip through them and just ask myself, or have your roommate read them, something like that, right? Quiz yourself on these things so you can memorize them as best you can, so that way when you get to test time, when you're facing a tick-down clock, and you have to answer these multiple choice questions, short answer questions, in a matter of minutes, right, you're ready for it. Yeah, if you have an absence, you can do a makeup exam. I don't think this will be a problem because you have a full week to take an exam. But just if it happens, you can read that. Okay, so those are our exams. Next, the fun parts. These are the most exciting exercises. They're much more exciting in person, but we got to make do with being online, so I've tried to keep them relatively interesting. We have what's called a moot court exercise. So this is a little complicated, so I'm going to try and keep it as simple as I can. Let me see if there's a flow chart. I used to have a flow chart in here. No, I don't. Okay. So here's the overview. Throughout the course of the semester, you're going to be asked to be a judge once and an attorney once, right? And what you're going to do is you're going to act out a role as if you were before the Supreme Court, either as a justice of the Supreme Court or an attorney arguing before the Supreme Court. And the way this process is going to work is that for each of these Supreme Courts, first, you're going to sign up, right? So as it says in the syllabus, if we skip down to about week 2, yeah, there it is. Starting in week 2, there's going to be a sign-up sheet. It's going to appear on Blackboard. It'll probably be like an Excel file or something. And you'll sign up once as an attorney and once as a judge. So if you know anybody that's taking the course and you want them to work with you as a partner, it's going to be groups of 2 or 3 on each side. It'd be a good idea to go ahead and reach out to them and say, hey, do you want to be my partner? Right? So you'll get to choose the weeks you want to sign up for. Now here's the catch. As you scroll down, you'll notice Moot Court 1, Moot Court 2, 3, 4. There's a total of 5 Moot Court scenarios. You do not know what the scenario will be yet. You won't know until a week in advance. But what you do know is that the week that it occurs. So, given that this is in week 5, you can pretty much guarantee that the week 5 Moot Court scenario is going to be something in the surrounding material. So, look at the surrounding issues. It's about privacy, abortion, reproduction, more privacy and abortion, sexuality, same-sex marriage, sexuality again, right to die. It's going to be about one of those issues, right? So it's going to be sort of, you can kind of eyeball what the topic is going to be about. But as I said, you will not actually know what it's about until 1 week prior when the scenario appears. So here's how this process works. You sign up for your moot court dates, attorney or judge. 1 week prior to the scenario, let me zoom in a little bit, 1 week prior to the scenario, in the week on a Blackboard folder, you will see the scenario suddenly appear, right? So, for example, moot court number 1 is in week number 4. So what that means is 1 week prior to this moot court scenario, meaning week 3, on September 6th, this scenario will appear in the week 4 folder. What do I mean by week 4 folder? Let's go to here. If we go to the course library, you notice I've numbered a bunch of folders that includes your material for the weeks. So here's week 1 through 4, week 5 through 9, blah, blah, blah. So your scenario will appear here in week 4 folder. And I'm on the wrong thing. There we go. Yeah. So, and it'll have here's what the scenarios are going to look like. It'll have a bunch of facts based on real cases. What I like to do is I take a case that's either petitioning to be before the Supreme Court, or maybe it was denied petition to be before the Supreme Court, and I'm going to say, act this out. So you'll be randomly assigned a position, right? So let's say you sign up to be a lawyer. You'll be randomly assigned to be party A or party B. You don't know in advance. And that's kind of the fun. Maybe you don't want that side to win. I don't care. That's the point of law, right? You don't get to pick your clients. You're assigned to this position and you need to do your best to defend it. So to help you out, to give you an idea of what I'm sort of talking about here, if you go to the course library, there's a tab called Moot Court Examples, and what you'll notice is there are example attorney briefs, example judicial opinions, and then also some old example scenarios I used to use. Let's see if I can click on this one. Make sure, maybe I don't know if it's a PDF or not. Oh, here it is. So it's a doc file. Oh, this was actually a real case and ended up getting to the Supreme Court. Wait, is this the first one or the second one? Second one. Yeah, this actually is part of our reading now. So this is like I used it in the past, and so what you can see is I took a real case, which at the time was being argued before the Fifth Circuit Court of Appeals, and I summarized the facts of the case, and then what I did is I said, blah, 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 and then I said, here we go. Judges 1A and 1B, so like Team 1, and attorneys, Team 1, you're both going to decide with Abigail Fisher. In other words, if you're a judge, you're going to take the position that you're going to rule in favor of Abigail Fisher. You're going to write a judicial opinion just as if you're a Supreme Court justice, as if Abigail Fisher won this case. And then you're going to explain why she won. Now, in reality, you might not want Abigail Fisher to win. I don't care. That's not the point. The point is for you to be able to formulate an argument that will help you make that point, right? And if you're an attorney, you're going to write a legal brief arguing why the Supreme Court should rule in her favor, right? If you're a Judge 2A and 2B, or attorneys 2A and 2B, you will then side with the defendant, which is the state of Texas. You will want UT at Austin, which is the state of Texas, to win, right? So as it says here, it's based off a real case. It was argued before this, blah, 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 blah. And then I will try to give you, I can almost guarantee I will give you a link to where the legal briefs can be found. Most of the time, it will be to this site. This is a website called SCOTUS Blog. Super fun, super nice. What they do is they follow SCOTUS, the Supreme Court of the United States, right? SCOTUS Blog has all sorts of useful information, docket number. Here's the ruling of the Fifth Circuit in the case I was just mentioning, the Fisher versus UT case, right? They actually have the ruling of the lower court. Super useful. If you're because since the scenarios I'm going to be using are based off real cases, there you go. The oral arguments. This case has later been decided by the Supreme Court. Here's the ruling by the Supreme Court and the summary of the ruling. And then take a look what they have here. Here's where SCOTUS Blog has covered it in a bunch of blog posts. But here's the stuff that you'll find useful. Here's the petition for writ of certiorari. Right, so this is asking the Supreme Court to take up their case. Here's some filings by friend of the court briefs on whether or not they should or should not take up the case. Here's the UT Texas case, right, saying do not take up the case. Here is Abigail Fisher's reply saying, no, the UT is wrong. Take up my case. The Supreme Court hears it in conference, and then look what they did. Petition granted. They will consider the case. So now that this has been done, they say, okay, fine. Now it's time to start filing your legal briefs. This is the stuff you'll find useful. So here's the brief of Abigail Fisher, right? So this stuff is going to be super useful if you're a judge or an attorney, because I'm not looking for you to reinvent the wheel, right? I'm looking for you to be able to read these things, these briefs and these rulings, to then fill in the gaps. Right? So somebody's really done all the work for you. I want you to just put this all together and show me that you understand and can put the argument into your own words, right? So the great thing about these cases too is, look, they've got, here's our argument, right? So all you have to do is take this and say, I'm going to sort of summarize this and put it into my own words, right? The other great thing is this, look, table of cited authorities. They cite the cases for you. So where should I look for precedent to help me win my argument? They have it all in alphabetical order for you, right? They have all the precedent you would need, and they give you even paid citations on where they used it. This is going to be really invaluable for you, right? So going back to the scenario, you'll see what you're assigned to, the position you're assigned to. I tell you that it's based off a real name. I'll give you some links to websites. Typically, it'll be Justia. It'll be a SCOTUS blog, and yeah, and then some other rules that might crop up are lumped in there as well. So, wrong thing. So yeah, so you'll have this scenario drops a week in advance, and then you'll have 1 full week to work with your partner or partners, either as a judge or an attorney, to then, if you're a judge, to write an opinion, or if you're an attorney, to write a brief. Here then I detail this in a little bit further, some sort of more fine-grained points. I'm not going to go through this in a lot of detail. You can read this on your own, but if I'm being a little unclear on how this scenario works, read the syllabus. It's painfully detailed, right? Like, for example, this is the order of the exercise. How does it proceed, right? The scenario appears. The teams will then write their briefs. They'll submit their things, yada, 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 right? So I just want to go through real quick and summarize what I'm looking for judges and attorneys, right? For judges, you have 2 tasks. Here's your rubric, and it tells you this. If you're a judge, you have to do this. You have to write an opinion. This you will work with your partner for. You and your partner judge, or partners judges if there's more than one, will write a clear, thoughtful opinion that's well written. It uses proper precedent, right? You're citing legal cases below. In law, you want to cite, because you don't want to pull it out of your butt. This is not creative writing. This is legal writing. You need to have evidence, and that evidence is based upon precedent, right? You need to guide your argument based on past rulings. And you need to meet these minimum requirements. If it's a standard moot court case where you have one partner as a judge, just you and another person, minimum 3 pages or 900 words, whichever it's less, right? That doesn't mean 2.5 pages. That means 3 pages. Right, not counting the works cited. You need 3. Now, for 2 people to write 3 pages in a week, that is not hard. In some instances, we're going to have you'll have 2 partners for a total of 3 judges. These are called super moot courts, right? This happens because sometimes the class is like crammed full, and there's only 5 scenarios. So you'll probably see this a lot. If you have 2 partners, it's the same thing. You just have to write 1 extra page or an extra 300 words, whichever's less, right? Of this, you can see that I'm looking for clear and thoughtful opinion, well-written, proper precedent, for a total of 9 points of your final grade. Is that opinion, that judicial opinion. You also need to turn it in on time, and that adds up to 1 point. So 10 points of your final grade is, 6, 8. 8 points of your final grade is the opinion, plus 1 is 9 points if it's turned in on time. Right. So that's your first task. You'll work with your partners to do that. The second thing you need to do is you need to write 3 questions. This is very easy. These questions are only, 2 sentences, 1 sentence maybe, right? Maybe 3 at most. You need to write 3 relevant questions that raise important legal issues in the case, right? It used to be that when I taught this course, you would do this in person. We would engage in an oral moot court where you would sit down, the attorneys would sit on one side, the judge would sit on the other, the attorneys would start reading their brief, or they'd say it out, they'd argue their brief, and then you, the judges, would interrupt in person, and then they would answer your questions, right? So you asking the question out loud would be your questions. But since we're not meeting in person, we can't do that. So what I need you to do is then come up with individual questions. So there's both a group component, writing your brief, and then an individual component of you writing 3 questions that will be given to the attorneys, right, to your rival attorneys. So in other words, what you want to think about when writing these questions, as it says here, there it is, acting alone, you're going to submit 3 questions that you'll be able to ask of your rival attorneys. So what I want you to do then is I want you to, as it says here, explore or weaken the arguments of the opposing lawyers. I want you to ask a question that, in other words, undermines what their likely argument is going to be. You don't know 100% exactly what they're going to say, but given that you have the briefs to read, you can read lower court cases, you have all this material to help you out, you can pretty much guess what they're going to say because you're writing the opposite. Right? Now, in reality, I realize this is not how a judge works. No judge should go into a case knowing which side is going to win or which side is going to lose. They should wait, right? I'm assigning you a position to make this scenario work. So you have 2 tasks as a judge. Work with your team to write the opinion, to make sure that the side that you're assigned prevails, and to write 3 questions by yourself and submit those questions. Where do you submit the questions when you're done? If you go to Blackboard, there's a tab. It's called Moot Court Submissions right there. Click on that one. There's 4 boxes. There's one for judge opinions. There's one for attorney briefs. There's one for judge 3 questions, and one for attorney reply to 3 questions. So if you're a judge, your team, I only need 1 paper, right, because it's 1 judicial opinion. You 2 or 3 judges need to submit into that box, and then you individually, as an individual judge, need to submit your 3 questions here. Right? And the guidelines for those are listed again in the syllabus, as is additional clarification. So that's your judge bit. And then I have also some bits about what I'm looking for in your papers here. You can read that on your own. And then due dates, you can read that on your own. And then some general tips, and you can read those on your own as well. So you've served your task as a judge. Now it's your time to be a lawyer, right? Because you're going to be one each, right? So for lawyers, this is a bit harder than being a judge. As a judge, it's relatively simple to write a ruling. As a lawyer, you have to formulate an argument. So as opposed to a judge, which will count for being 15 points of your final grade, for lawyers, your rubric is here, this will count for a quarter of your grade. It's the same as an exam. You need to treat this very seriously, right? This is a huge chunk of your grade. So what am I looking for if you're an attorney? The scenario works the exact same way. 1 week prior to your moot court scenario, it will appear on Blackboard. You then will work with your attorney friends, your colleagues, right, on your team, depending on what team you're on, right, 1 or 2, to then come up with a argument that advocates for the position that you will prevail. Right here. Sorry, I'm clicking on the wrong thing. This written portion will count for 13 points of your final grade, plus the extra 2 points for submitting it on time. Right. So what am I looking for when you submit these things? It says here that a single team needs to upload their one document that explains why their single side should prevail. Research and outline your argument before you begin writing. I recommend coming up with an outline, right? So why should you win? What are the reasons, right? You want to start with outlining the facts, talking about why your side should prevail, and then detailing each of those points, right? So it says consult all the directly relevant cases. There's also some examples on Blackboard. Also, it says here it would be wise to read the full case text the moot court scenario is based on, and you can find these on Justia. So in other words, don't just read the summary that I give you in the scenario. You need to go outside of that and read the full case text, right? So that's your written portion. Let's look at what I'm looking for. Very similar to judges, the only difference is that now you're arguing on behalf of a side. Clear and thoughtful presentation of your argument, appropriately utilizes precedent and cites it appropriately, logical, consistent, and well written. Notice here the paper requirements are longer. Minimum 4.5 pages or 1,350 words, whichever is less. That's 4.5 pages, not 4 pages, 4.5, right? So that means 4 plus half of another page minimum. You should have no problem writing these papers. There is plenty of material. Remember what I showed you when we looked at the last bit on, you know, these like these briefs. This is 57 pages here, right? If they can write 57 pages on the topic, you can easily come up with 4.5, right? It should be no problem coming up with this material. Next. And then if you have what's called a super moot court, meaning instead of having one partner, you have 2 lawyer partners, you will have a longer requirement. You'll have minimum 6 pages or 1,800 words, right? Not surprisingly. So think about it. 3 people to come up with, that's 2 pages per person, right? That is not hard over a week. That is not a lot of writing. You should be able to do this. The difficulty is coordinating with your partners to divvy up the task, right? So you're going to need a lot of, you know, either meeting in person or phone calls or Skyping or something like that, right? And then, of course, submit it on time. That'll earn you the final bit of those. That'll earn you 2 points. Late submissions means deduction. The second thing you need to do is, unlike the judges, where you were writing questions to attorneys, you are now going to be writing you're going to be answering those questions. So the way this process is going to work is, once the judges submit their questions, right, they'll have a week to do this. What I'm going to do then is, after they've submitted this, I'm going to take all of their questions, I'm going to put them into one document file, and I'm going to edit them, because sometimes people submit crappy questions, so I'll just say, like, this is crap, don't answer that one, or I'll try and spruce it up so it's easier for you to understand. And now you will act alone as an individual attorney, and you'll answer any 3 of those questions of your choosing. So given that you're going to have at minimum something like, I'm going to give you all the questions from the judges on both sides, right? So you're going to end up with a minimum of, well, let's assume it's a really good week. You have a total of, let's say, 4 judges, right? 2 on each side. Each one's writing 3 questions. You're going to have a total of 12 questions to choose from. You will pick any of those 3, and you will answer those. And the answers have to be 100 to 150 words. Typically, you want more here. You really want to expound on your point, cite precedent, really drive home your answer, right? If we have a super moot court where there's teams of 3 as opposed to teams of 2, you're going to have even more to choose from. You will have 1 week to answer those 3 questions of your choosing. And when you're done, you'll go back to Blackboard and you'll go to the moot court submissions tab, and then you'll submit it here. Right? So it's going to be a little bit wonky in terms of submission, because think about how this process works. Let's go to the syllabus here, and you'll see what I mean. So your scenario, this is actually a benefit for you doing it online. You're actually going to have more time than I would give to my students that do it in class. and here's why. So you're in moot court scenario 1, right? This is, yeah. So you're in moot court scenario 1. Your scenario is actually going to appear 1 week prior. So it's going to appear September 6th, right? That's when your scenario appears. You now then have until the end of the week of the moot court listed. So you actually technically have 2 weeks, right? You have this week where your moot court scenario appears, then you have this week, and it's not due until the end of that week, the 19th. Normally when I do this in class, your scenario would appear here, and then you only would have, it would be due when that class date was, right? So you actually have about an extra 4 or 5 days versus normal classes. So if you're a judge, here's how your week's going to look. Moot court scenario appears here, the week prior to the moot court. You then have until the end of week 4, which is where moot court scenario is listed, the 19th at 11:59 p.m., to come up with your single judge's opinion, and then your individual 3 questions. That's not hard, right? For attorneys, you're going to have those same 2 weeks to come up with your legal brief. Then I'm going to take those judges' questions, and then you'll have 1 extra week, right? The end of the next week, week 5, you'll have until the 26th, right, at 11:59 p.m. to answer those 3 questions. Trust me, it is not going to take you a week to answer 3 short questions that are only 100 to 150 words. This is not meant to, like, break the bank here, right? I'm not trying to kill you. And then finally, the last bit here, just to wrap things up, is I've already mentioned this before, but there's the possibility that you're going to have this talks about submission. You know, you can ignore that. And make sure to cite your sources. It's going to be run through SafeAssign, so don't plagiarize. Right, use quotations and stuff. As I mentioned, the one thing I wanted to drive home here is this is an upper level course. Don't pass the buck. I don't want to get reports of this person did not contribute. It's going to piss me off and I'm going to give you a low grade. Don't do it. Right? Work your butt. You're going to know who your partner is in advance. So reach out early, right? Reach out as soon as you can and say, we're partners. What's the best time to contact you? You know, when are you free? Are you going to be on campus? Yada, yada. And the other thing I've already mentioned before, it's likely that many, if not all, of our moot court scenarios are going to be what's called super moot courts. The only difference is that instead of being an attorney 1A and 1B, like on here, right? Remember how it said, like, right there, it said attorney 1A and 1B and judge 1A and 1B. Instead, it's going to be 1A, 1B, and 1C. So in other words, you're going to have teams of, instead of being teams of 2, you're going to be teams of 3. The only difference is that for your papers, for attorneys, they're going to be longer. And for judges, they're going to be longer. That's it. You as attorneys will still answer 3 questions. You as judges will still submit 3 individual questions. That does not change. The only thing that will change is that your brief or your judicial opinion will be longer. That's it. Okay, let's go back to the rubric. I think we covered pretty much everything. Oh, the last thing we didn't cover is this viewership. I already mentioned it, but just to reiterate, participation. Normally I do, as I said, the in-class call-on. We're not going to do that. All you have to do now is you have to click on the link to view the video lecture. If you go to Blackboard, there's going to be a link. It's going to say video lectures. Right now the folder is empty because I haven't posted anything yet. Every week I expect you to watch the videos for that week. You don't have to watch the whole thing. As it says here, you can skip around. That's fine, but you need to click on it. Blackboard records if you've viewed something. And I can even have it record how long you viewed it for, but I'm not really going to care about that as much. I simply want to know that you viewed it. So before the week is over, you need to watch the video lecture. That's it. And then if you do, I'll give you credit. If you don't, you don't. You don't get credit. That's it. So since there are 15 weeks of lectures, each week is worth 0.66 of your final grade, for a total of, this is 10 points of your final grade. So there you go. Again, you can watch these at your convenience. I'm only asking that you keep up. So you need to watch the video within that week, by the end of the week, right? There you go. There are possible bonus assignments. I'll give those to the entirety of the class. The course email system is definitely a good idea. You're going to need it. It's located here on Blackboard. It's called there to send email, right? Just don't use it to sell crap because that's really annoying and it pisses people off. Okay, you can read the honor code on your own. You could read the sick drop policy on your own. Student disabilities, you can read that on your own. If you need to do that, contact the DRC immediately so I can accommodate your whatever accommodations you need. And then schedule of readings. I won't belabor this. I just want to point out a couple things. It says here, the syllabus contains things that are called optional readings. These are the basis for some of the bonus questions, as well as the concurrences and dissents in the cases. The optional readings are not required, but if your moot court is in that week, you're probably going to want to at least read the summary. What I'm talking about is something like this, optional readings, right? Optional readings. If you have a moot court in that week or maybe one of the surrounding weeks, these things are meant to help you particularly, right? So let's take a look real quick at what we're going to be doing. First week, we're going to be looking at some of the textbook stuff that's going to get you familiarized with the judiciary. This is really the only time we're going to be reading chapters from the textbook. From there, it's going to be nothing but cases, right? That said, if you're ever stuck, take a look at the chapters. They really connect the cases together. It gives you sort of a big picture thing. That's what I'm going to be trying to do in the lectures. I'm going to be trying to link these cases together for you. From there, we're going to be looking at the issue of selective incorporation, applying the Bill of Rights to the states, and then we're pretty much going to proceed in order. We're going to be looking at the First Amendment, Second Amendment, on and on and on. First Amendment speech, expression, government speech, obscenity, which is like pornography, student speech, press, association. Then we're going to be looking at religion, right, establishment clauses, free exercise clauses, the Second Amendment, the right to bear arms. You notice that we go from second to fourth. That's because there is no Third Amendment cases. Third Amendment is quartering troops in homes. We've never had a Supreme Court case about it. And then we go into our first midterm, halfway through the semester, right? You have a week to complete that. Fourth Amendment, search and seizure. Fifth Amendment, self-incrimination, right to trial. The Eighth Amendment, we're just going to be, excuse me, looking at death penalty. There are other issues dealing with cruel and unusual punishment and excessive fines and bail, excessive bail and fines. But we're just going to be focusing primarily on the death penalty. From there, we're going to move into the 14th Amendment. Let me get rid of this box, stupid thing. The 14th Amendment, dealing with the due process clause. And then we're going to be looking at equal protection analysis. So we're going to be looking at equal protection and due process under the law for things like consideration of race for contracts, for higher education, voting and representation. We'll touch on that as well because that's an equal protection issue. Sex and gender, abortion, privacy, sexual orientation, same-sex marriage, right to die, and then other suspect classifications like age, disability status, income, yada, yada, yada. And then we get to the final. And there it is. The one thing I want to end on here, I had two things actually. Oh yes, this. I try to make the syllabus easy to read, but invariably I get one or two students that get confused. All of these cases are required reading. If you see a case on here, like let's take this week 14 for example, Romer versus Evans, it has a BB next to it. BB means Blackboard, right? The way you find it is you'll go to the week 14 folder on Blackboard. They're all in chronological order, and you'll find this. It is not in your textbook. If you see a case like this, Lawrence versus Texas, it's in your textbook. The reason that's why there's no BB next to it. Now, where do you find the page number? You can either go to the back of the book in the index, and they're listed alphabetically. By the way, in the textbook, all the cases in caps means if it's in caps in the index, it means it's in the book, the abridged case text. Or you can just go to the table of contents. And here's an example. We're pretty much going to proceed in the exact same order as the book. So you can just go to the table. This is the table of contents. This is right to privacy. And then there's Lawrence versus Texas right there. And there's the page number. This might be from a different edition, so that page number might not line up. But there you go. We're going to be reading almost all of the cases in the textbook, but not all of them, right? So just keep that in mind. The other thing I wanted to say is don't let this confuse you. Optional readings, right? Optional. Same thing though, Blackboard. Right, that's where they're located, or if there's no Blackboard, then they're in the textbook. You do not have to read these, but again, they're the basis for potential bonus questions. So keep that in mind. It can also help you out if you're doing a moot court scenario in that week. At least it might, right? The last thing I want to end with is this. How to be a better writer in 8 slides. So this is on Blackboard, so I'll go through it really quickly. But I came up with this after teaching this course a number of times, and I've come up with 8 slides that will make you a better writer, not just for this class, but for every class. I want you, before you write a single word in my class, to read these slides. And if you don't, I'm going to yell at you in your paper because it means you didn't. Before you write anything, for any class, read these slides. All right, slide number 1. How to be a better writer in 8 slides. Cite your sources, right? It's not enough to use a quote. If ever you use a quote, you need to have a citation after it. You should never, ever, ever use a quotation mark without a citation. Use them sparingly, right? Put things into your own words. Still use a citation. Much more interesting to read what you said and not a series of quotes. Avoid block quotes. Block quotes are quotes, as it says here, where you have something that is 4 or more lines of text. You need to have it offset as a block quote. Avoid them. They're annoying. Whenever I see a block quote in a text or like a book or something, I always skip it. Because if it's that much information, I'm losing interest, right? Here's what I mean by a block quote. So assume this is a quote, right? Notice I've offset it from the text. It's indented further than it would be, right? It's basically like a paragraph, but the whole thing is like indented that far. If ever you use a quote that is 4 or more lines, it needs to be offset as a block quote. You'll notice that for block quotes, you don't need quotation marks. You technically can use them if you want to, but you don't need it because it's already offset as a block quote. Again, don't use them. They're boring, right? Nobody wants to read what somebody else says. That's a big-ass paragraph. Use your own words, right? It makes you look lazy. Next, how to use brackets. So what happens and how to manipulate quotes. So what if somebody says something, but it's not quite what I want, right? Or they said something that's just too long, and I want to make it shorter so that it makes more sense, right? You can use brackets to manipulate what somebody else says to fit into the context of your sentence. Here's an example. Here's the original quote. Congressional majorities obviously do not shut out minorities in this fashion. It would make no sense to do so. The costs of cutting in minority members are very low, whereas the cost of losing majority control in a cutthroat partisan politics of this kind would be very high. It's a quote from Mayhew's 1974 book. I think it's Congress, the Electoral Connection, if I remember correctly. Yeah, I think so. Yeah. So, what if I want to change something, right? What if I want to edit this thing down a bit, or if I want to put it in my own words? So here's what I have, right? Take a look at how I've revised this. As Mayhew, 1974, 121. Why did I put that? Because that's the citation, right? Year, year, page number. Should always have for a quote. As Mayhew, 1974, page 121 noted, the party holding the majority in Congress does not have an incentive to shut out the minority because, now look what I did. It would make no sense up here. It would make no sense. Notice what I did to the it. I put the I in brackets. Why did I do that? Because it doesn't make sense to have an uppercase I. I'm not starting a sentence, right? If I did that, it would be incorrect grammar. So what I do is I put a brackets. I change it to a lowercase I. Why did I do that? Because I have done that. Anytime you make a change to a quote, you put the change in brackets. So now this fits into my sentence because it would make no sense to do so. Now look what I did. To do so, I don't want this whole middle bit, right? I don't need all of this stuff, right? This bit is irrelevant here. So I can just, so I need to delete all of it, right? I want to strike through. So how do I go about doing that? Well, what I do is then I either could do something like this and put in ellipses, ... or I could put in language to bridge the gap, which I did here. So I said, so, since the cost of losing, right? This shows that I've edited the sentence, that I've added something in here and something has been changed. Now notice, this is how also, by the way, people are often accused of manipulating quotes in the media, because I could take this quote and I could cut out a big chunk here, and that might have actually altered the entire meaning of the sentence. Technically, it is still fair game, because I've noted that I have changed the actual quote with the brackets, right? It would make no sense to do so since the cost of losing majority control, blah, 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 blah. Now notice, since I have the citation, up here, I do not need to put the citation here, right? As long as it's in the sentence, it's fine. Next, I mentioned ellipses. So take a look at this quote. The Supreme Court will only grant petitions for certiorari if 4 of the 9 justices agree to hear a case. This is known as the rule of 4. This is true, right? That's my original quote. Here's the revised quote. Let's say I want to cut out a bit of material. So I want to cut out everything I want to cut out this bit, will only. I don't know why I want to cut it out, but I want to cut it out. What I need to do then is to manipulate the quote. If I want to cut it out, I need to put in bracket, ... which are called ellipses, and then a close bracket. The Supreme Court grants, notice I had to change this, because if I say the Supreme Court grant petitions, doesn't make sense. The Supreme Court grants petitions for writ of certiorari. I have to make it grammatically correct. And then notice that also means that I have to add a comma here, and I did it with brackets, right? Any manipulations to sentences need to be done in brackets, and yeah, there you go. Finally, avoid all personal pronouns. So don't use he, she, it, they, we. Never use them, especially the word they. It is very confusing, and it is not good for formal writing, right? Actually, I don't need a comma there either. There we go. For example, if I said, like, they went to the pond. Who went to the pond, right? It's vague. You need to tell me. Say, John and Jill went to the pond. particularly when you're talking in cases, because you're going to be talking about litigants, and oftentimes there are more than one, and I need to know which one. Avoid personal pronouns at all costs, right? You want to use particularly second person, third person pronouns. Use proper nouns. Use names, right? Yeah, and this goes on. This just belabors the same point. So, take a look at this sentence. When the senators realized the bill would be defeated, they tried to postpone the vote but failed. It was a disaster. But the "it" in this sentence is unclear, right? Was it the bill or was it the effort to postpone? This is just an example of how using one of these, unclear pronouns doesn't make sense. If instead I use a proper pronoun, right? The attempt to delay the vote was a disaster. I've now I've used an actual noun. It's clearer than simply using pronouns. All right, last few slides here is just 3 more. 1, avoid passive voice. You can read that on your own. I don't care what you think. I don't care what you believe. State it assertively. Use commas correctly. More tricky is also a bad thing. This should just be tricky. It's bad writing on my part. And then it says here, just remember that when you're using commas, you're talking about separate clauses, right? So imagine it as a pause. And these things can be important, right? As the meme here says, if I said, let's eat grandma, or let us eat grandma, if I said, that literally would mean, let's eat grandma, like let's devour her body, versus let's eat grandma, right? Let's eat, and then grandma is the source of the eating, right? The direction of the phrase, the command there. And so this can save lives, right? Because you're literally eating your grandmother, or you're telling her you want to eat, right? And then, of course, Grumpy Cat prefers the former. The last bit, and perhaps the most important, and this is specific to law. So how do we cite legal cases? And what do these citations mean? The Supreme Court cases are formatted like this. This is the actual citation for Miranda versus Arizona. What does this mean? Miranda is the one appealing the case, the appellant. And how do I know Miranda is the appellant? Because the appellant name always goes first, right? The plural or the reference would be the appellee. So if I'm referring back to that person, it'd be the same thing as spelled as appellant, but with 2 e's. So they're appealing the case. That's why they're called appellant. And this is the respondent. Right. Sometimes it's also called the petitioner because they're the person petitioning for the writ of certiorari. Petitioner, appellant, same thing. They're appealing, right? They've lost below. This is the respondent responding to the case, or So why are they responding? Because they have won below, and they don't need the case to be appealed, right? When you win, you don't appeal your case. So petitioner and respondent. Notice here, case names are in italics. And they have a V dot, not capital V, not VS. This is not Street Fighter, right? Lowercase v, period. Case names in italics. The numbers, then. What is this 384 US, yada, yada, yada. The 384, as it says here, are the numbers, numbers under the court's printed volume number. So this is where the Supreme Court has put it in their Supreme Court docket, right? And then after that is the court at issue. So this is U.S. At lower levels, you'll see different things. Like you'll see like F dot such and such, or F dot D, which is like referring to a federal district court. Or you'll have like CIR, or like 5 CIR, which refers to the Fifth Circuit, right? So this is telling us where the case was heard. Sometimes you'll also see, instead of U.S., you'll see USC, which is the same thing, United States Supreme Court, right? And then after that, you'll see these 3 things. These 3 things start with the page number. This is a bit weird because the Supreme Court doesn't actually have like a publishing company. Instead, there are different companies that publish the Supreme Court in like bound volumes. So they'll have a number for where the page citation begins. So a lot of modern Supreme Court cases don't have this at all. So you'll see something like, let me show an example. So this is, where we go? So this is Our Lady of Guadalupe School versus Morrissey Baru. This is a case we're going to be taking up this year. It's a new one, 2020. Take a look at that. 591 U.S. Supreme Court. Notice this dash bit. Because it doesn't have a publishing company page number yet. So they'll just put 3 underline, and then that's it, right? So there still is always going to be this, because this is the Supreme Court's own sort of filing system and the year, but there is no subsequent thing there. So, where are we going here? So if there is one of these, this is the actual page number for the case that you would cite when referencing it. For the purposes for our class, I'm not usually too concerned with the page numbers. I mostly just want to know that you have the case citation and the year, Right. So that's what those numbers mean in case you didn't know or were unclear about it. Okay, that's it. That's our opening lecture, intro to the course, and that's our how to be a better writer in 8 slides. Yeah, if you have any questions about this syllabus, poke around Blackboard. Let's make sure we actually hit everything there. The slides and all that other supporting material will be available on Blackboard too in the course library. Okay, that's it.